just want to greet you, and the key speech will be done by Dr. Fidelma Donlon. She's the registrar of the new Kosovo Tribunal, or the new specialist chambers of Kosovo. We are glad that you come in such a great number. It will be very interesting today. We will hear about the international criminal justice, the past of it, present, and the future. We really have the creme of la creme, best of the best. People who've been in this field for years, who dealt with opening new courts, closing all courts, and practicing in front of those courts for years. So I just want to call or Dr. Fidelma Donlon to address you with a key speech, and we will continue. Thank you, and welcome again.
Thank you. I successfully reached the stage without injury. Good morning, ladies and gentlemen, colleagues and friends. It is an honour to be with you here today, to have an opportunity to make some remarks about the Kosovo Specialist Chambers. Recently at an ICTY legacy event, specifically the story of the defence practising before the ICTY, Karsten Stan, Professor Stan, remarked that fair and efficient defence serves obviously not only the defendant, but it protects the equality of arms between prosecution and defence and protects the right of the accused to a fair trial. Obviously, effective defence is also central to the integrity of any proceedings. Today, I would like to concentrate my remarks on the defence function in the Kosovo Specialist Chambers, but I would also like to highlight two very innovative elements in the design of the Kosovo Chambers, which relate to the further and enhanced protection of the fundamental rights and freedoms of those who may appear before the court and others who have business with it. Firstly, and very briefly, the Kosovo Specialist Chambers was established pursuant to an exchange of letters between the former EU High Representative and the former President of Kosovo in 2014. That exchange of letters provided, critically, that the proceedings would be relocated to a third state, which we now know is the Netherlands, and furthermore, that within each court level of the Kosovo system, specialist internationalised chambers would be created. Subsequently, in 2015, by 2/3 majority, the Parliament of Kosovo adopted the law on the Specialist Chambers and Specialist Prosecutors Office, together with a constitutional amendment, creating the chambers, and separately from the chambers, the Prosecutor's Office. With reference to the chambers is created of two organs, the Judges' Chambers and the Registry. In relation to our judges, 20 judges have been appointed to a roster. Currently, the only sitting judge is the President of the Court, Ekaterina Trendivalova, who took office in January of 2017. In relation to the progress made, in February of 2017, 19 other judges were appointed to the roster. In March, the first plenary of judges was held and the rules of procedure and evidence of the chambers were adopted, and thereafter referred to the Constitutional Chamber. As indicated today, I wanted to focus on innovative elements. One of the innovative elements of the Kosovo Chambers is the existence, firstly, of a constitutional chamber as an integral part of our system and institution. So, as I mentioned, there are international judges and specialist chambers at each level of the Kosovo court system. That is the basic court, the appellate court, the Supreme Court, and the constitutional chamber. What is particularly innovative is further to the adoption of the rules of procedure and evidence by the plenary of judges, the law provided that the judges had to refer the rules to the Constitutional Chamber for review by the Chamber for compliance with the Kosovo Constitution and international human rights standards. After the first referral, the Constitutional Chamber held that 9 out of 208 rules were not fully compliant with Chapter 2 of the Constitution, which stipulates the fundamental rights and freedoms, which most of you will recognise from the European Convention on Human Rights and the International Covenant on Civil and Political Rights. Subsequently, the rules were returned to the plenary. The 9 rules were reviewed and amended and thereafter returned to the Constitutional Chamber for review. In June of this year, the Chamber held that the body of rules, the entire rules of procedure and evidence, were compliant with the Kosovo Constitution, and in July the rules entered into force, marking the readiness of the Chambers to receive filings. With reference to additional remedies that may be available for individuals who feel or potentially allege that rights have been violated, another critically innovative element of the Kosovo Specialist Chambers is the existence of an Ombudsperson's Office. The Ombudsperson's Office is situated within the registry, but by law and by rules of procedure and evidence will operate independently. In summary, the Ombudsperson is defined as the entity which will act independently to defend and monitor and protect the rights and freedoms of individuals who appear before the court. Moreover, the Ombudsperson may make recommendations to the Chambers as well as the Specialist Prosecutor's Office. Moving on to what is critically relevant for the audience today, the defence function of the Kosovo Specialist Chambers. Within our structure, the Defence Office is located within the registry. The Defence Office serves as the entity which will administer the list of counsel as well as a legal aid scheme. Many of you may know that recently we opened up what we refer to as a call for contributions, which is the notification that we are now seeking qualified defence counsel to apply to the Kosovo Specialist Chambers to be registered on the list of counsel entitled to appear before the Chambers. That advertisement took place less than a month ago, and thus far we are very happy with the number of applications that we have received, and strongly encourage those of you who are interested to please apply for the list of counsel. Frequently, both in Kosovo and in other locations, I have been asked about lessons learned from my experience in the field of international criminal justice since 2000 and building institutions. I'm asked why are the Kosovo Specialist Chambers different, but I'm also asked what lessons have you learned and what have you applied in building this entity. With specific reference to the defence, I would like to point out that from the inception of the court planning team, which was created in 2015, we did have an individual, a specific post related to the building of the defence component in compliance with the law, as well as the Defence Office. So, as has been noted in the excellent book published by Collie, Defence Perspectives, in a number of chapters that I have read, I see, and I know from personal experience, that all too often the defence function is perhaps forgotten about in some cases, or not given appropriate attention. So as I've mentioned previously in terms of lessons adopted, that is one thing that we push for at the very early stages, saying regardless of the fact that we are not in trial, we still need to pay full attention to building defence function as well as defence capacity. Moreover, we have commenced our outreach in the sense of indicating to the public, wherever they may listen to us, that my business as registrar is delivering on a mandate of a fair trial in a safe and secure environment conducive to the administration of justice. To do that, there needs to be qualified defence registered with the list of counsel for the court, as well as for those who stand accused in the future before it. So as part of our efforts to ensure that our message is heard, we have started our outreach activities. and have spent time in Kosovo. Most recently, the head of my defence office, together with the head of my victims participation office, who are here with me today, have been to Kosovo, have met with the president of the Bar Association and a number of lawyers. Also recently, myself and the president have been to Kosovo to meet with the Bar Association, as well as the Ombudsperson and civil society, again to reiterate the fact that our business is fair trial. That is our objective, and also to encourage qualified applicants to now apply to the court for the list of counsel. Finally, I would just like to remark on a very practical level, and again reflecting in Dominic's chapter, I believe, in Defence Perspective, the book, that the journey of the defence in international circles did not have an easy start, and certainly before the ICTY you were without office space. So as I have been recently asked, I would like to confirm that the premises that are being renovated for us, and that I was recently in with a hard hat and steel boots, does have defence office space, which is actually very nice and has good light, good aspects and good space. So you are being thought of, and again, I can only encourage you to apply for our list of counsel. Finally, rather than closing on the new kid in town, as many refer to it, the Kosovo Specialist Chambers, I would like to conclude by remarking on the Association of Defence Counsel. Colleen spoke about it recently, the birth of the organisation and why she loves it. She referenced many aspects of the work of the association since its inception, including the assistance rendered to counsel in the early years of dealing with thorny issues, including ethical matters, but also critically creating and developing a training function, a training committee that focused on working with fellow practitioners to bring everyone to the point of understanding the different system that they would be operating in before the ICTY. Recently, I have returned from Colombia, where I was speaking with individuals who are in the process of establishment of the Special Tribunal for Peace in Colombia. And as an aspect of that, I noted that in relation to defence capacity there, although they will be using the National Principal Defender system, they have not yet harnessed the concept of drawing in on the skills and expertise of defence practitioners that have worked in the area of international humanitarian law since 1993. So in terms of my recommendations, one of them was, although you may use your national system, your principal defender system, which is very adequate with very qualified people, there is no doubt that there is capacity in terms of expertise from a defence perspective that is of great value. So, as Colleen has indicated, the ADC Manual on Best Practices has been translated into Spanish, so I will be speaking to you later about referring that to another jurisdiction. And the expertise that I referred to is here in the room with me. So, on that note, I congratulate the Association of Defence Counsel for all your stellar work since inception. I wish you the very best of luck in the future, and I wish you a very successful conference. Thank you very much.